Hello there. So today we are going to be talking about 5 things parents with minor children should know about estate planning. Before I get started, as we let people join our webinar here, I just want to confirm that you can hear me and see the slideshow okay. So if you can put that in the comment section, in the chats, the Q&A, anything there, to be able to let me know that you're able to hear me and see me, then that would be wonderful. And then we'll get started in just a moment. Okay, perfect. Okay, let's go ahead and get started. So my name is Krista Hermans. I'm an estate planning attorney. Our firm is Hermans Law, where you may know us as estate planning mom and estate planning dad. Our firm was started about 8 years ago by me. I was a new mom at the time, working as an associate attorney at a firm. And I really just wanted to create an environment where, as a new mom, I would be able to be an attorney while also being a mom. And that's really where Estate Planning Mom was created. I just found myself working with a lot of moms at the time and moms groups and really educating parents on how they could put legal plans in place to make sure that their minor children were protected. Because as a new mom, that was top of my mind. And over the years, our firm has really just kind of flourished with this culture of being very family oriented in that practice. Okay. So quick agenda for our webinar today. I'm going to talk about what happens without a plan in place. I will talk about the 5 things to consider when looking at planning for families with minor children. What is the difference between a trust and a will? I know that's a big question I hear oftentimes. And then what is right for you? This is ultimately the decision that you need to make on what's the best plan for your family. Okay, so no plan at all. So when we look at not having an estate plan in place, we're going to look at 2 areas. We're going to look at guardianship, so for your minor children, and then what the actual court process looks like. So the first one we look at guardianship. This is if something were to happen to you and the other parent of your children, and this guardianship is what would happen to them as a person. So who would have control over them, as well as who would have control over their assets. Those are the kind of 2 areas that we look at. So a guardianship proceeding would need to occur. And this is where somebody, whether it's a relative, a close family friend, would petition the court for guardianship of your children. The problem that you have in this situation is because you have no legal plans in place, the court, when taking this petition into account, has no idea what you actually would want to happen to your children, who you would actually want to raise them. So you have a a judge making a decision based on the information they have in front of them, not knowing your family situation, not knowing your relationship with these potential guardians, not knowing, if you would even want them to be guardians. And that's really where the problem comes in when you don't have a legal plan in place. You are letting the court make a decision without any input from you. Okay. The next thing we look at is when somebody actually passes away. And this is where the assets that they own in their individual name would then go through a probate court proceeding. The probate court proceeding is where somebody would file a petition with the court, and after somebody has passed away, and any assets that they own in their individual name would then basically be brought into this probate estate. It's put out in the newspaper, creditors are notified, it's a public record, and as all of these assets are kind of going through this probate court process, at the end, it is when bills are paid, attorney's fees, and then whatever is left is then split between the heirs or beneficiaries of the state, depending on if there's a will or not. So oftentimes, when people understand what probate court is, they want to avoid it. And we see it because probate is a very long process. It can generally take about 1 to 2 years for a probate court proceeding to actually complete from start, from the time you file that first petition until the time it actually completes. That's just an average where nobody is fighting, right? Everybody is getting along. It just takes that long to actually happen. It's also a public record. Anybody can go down to the courthouse, pull the documents, and find out what you own, who your beneficiaries are, and who you owe money to. The last thing is that probate court is very expensive, and most people don't understand it until they actually have to go through it. So let's just say that you have a gross estate worth $500,000. And let's say that it's made up of a home that has a fair market value, how much it would actually sell for, not how much equity you have, of $490,000 and $10,000 in various bank accounts. So a total probate estate of $500,000. The statutory fees for a $500,000 estate are $26,000. In addition to that, you have costs associated with it. So the filing fees, probate referee fees, bond fees, publication fees, that's another $2,000 to $3,000. You're looking at almost $30,000 for a probate estate worth $500,000 to go through that process. Now, that's a lot of money that can absolutely be avoided by having proper documentation in place, by having an estate plan, by having a funded trust. And we're going to talk more about that. The other side, since we really want to focus on minor children in this webinar, is how are minor children going to receive that money? Well, through that court process, the court cannot give the money to minors. And so it's going to go into a court blocked account where they will then receive that money when they turn 18 years old. And for some life insurance policies that I've seen, that is a lot of money to give to an 18-year-old that probably is not financially mature enough to make the right decisions. Okay. Okay. So I'm going to go through 5 things that are important for you to consider as a parent of minor children. The first one is nominating long-term guardians. So when we think about long-term guardians, this is, people have this idea of a long-term guardian of like being like a godparent or, somebody like that's close in their family. And it's, while those are all wonderful things to have, there's nothing legally in writing that makes those people the guardians. And so this is where nominating in a legal document a guardian of your children if something were to happen to you and the other parent of your children. So when you look at nominating long-term guardians, you want to take into account a lot of different factors. What is the age of the people that you are looking at nominating? Where do they live? Do they have children of their own? Where are they at from a financial perspective? Is it going to be a huge burden for them to take on your children in their household? Not that they won't necessarily have any money from potential life insurance policies or retirement accounts, but it's always things to consider from that aspect. What is the relationship that they have with your children? What is the age of your children that if something were to happen to you, if your kids are in high school, and are they going to have to move across the country? And so it's important when taking into account guardian nominations, you put all of these factors into account. And don't just nominate guardians because it's who you think deserves to be guardian, right? Who is the best fit? Who is the best person that will love and support and educate your child when you are not able to? I know as a mom, this is the hardest part of estate planning. And oftentimes people put it off because they don't want to have to think about it, right? They don't ever want to have to think about not being there for their kids. And I understand that. I I am a mom, I have 2 young girls, but it makes me feel better and it gives me peace of mind knowing that if something were to happen, I have legal documents in place of what my wishes are, because those wishes that are legally in writing are your voice, right? They're your voice when you no longer have a voice. And that is your ability to communicate with the court and say, if something were to happen to me, this is who I would want to be guardians for my minor children. Oftentimes I see when couples are coming together and doing their guardian nomination, they can't agree, right? There's gonna have to be some, you're gonna have to make some decisions and probably give and take on some different decisions on who you want for guardians, because having something listed is better than having nothing at all, okay? Okay. Next, let's go on to alternate guardians. So it's important when you're doing your guardian nomination for your minor children. And again, minor children are children that are under the age of 18, right? They are not the age of majority in the state of California. So nominating guardians for your minor children, it's important to have not just one guardian nominated, but alternate guardians, right? So I generally would recommend that you have one primary and then two backups. So for a total of three, if you can. You never know what season of life somebody is going to be in, right? Maybe, if something were to happen to you, and then guardians had to come into play, what if the guardian that you have listed is going through cancer treatment and they have kids of their own and there's just no way that they can take on any other responsibility like that at that time in their life. Or what if you only have one guardian listed and let's say it's your sister and you're in a car with your sister and there's an accident, right? Then at that point, there's nobody listed as a guardian. So it's important to identify then who you would want as the primary and then who you would want as backups to that primary guardian. And so you have your alternates listed there. Okay, next. You want to document your wishes very specifically. So, what I like to think about this is you have the ability when doing your guardian nomination to make your wishes very specific, right, on what you actually want. And so let's just say I go back to the one where, I said you're nominating your sister as the guardian. Well, sometimes I see people that say, well, my sister's married, so I want to put her husband on there. And so my general recommendation would be, well, if something were to happen to your sister, would you necessarily want your brother-in-law to be the guardians of your children? Right? Sometimes clients say yes, sometimes they say no. So you have the ability to just put sister, right? And not have brother in there or brother-in-law in there. So that way it would then go to that alternate guardian that you have listed next. So whatever those wishes are, if you do want sister, maybe you want sister and brother-in-law to be there together. But if something happened to sister, you could say, I do not want brother-in-law to be there if sister cannot act. And then it would go to your alternate person. So when you are doing these legal documents, it is your documents, right? You get to put that language in there of what makes sense for you and fits your family situation. Okay, next, nominating short-term guardians. So this is something that a lot of times people don't consider when they look at nominating guardians for their minor children. But short-term guardians is also a very important aspect. So when we look at short-term guardians, we're looking at planning for that kind of in between. So maybe you went on a date, right? You had date night and there was a car accident. Well, if something happened to you and you had your minor children at home and they were with a babysitter, the babysitter wouldn't be able to continue to take care of your kids. The babysitter's parents wouldn't necessarily be able to take your kids. And what if you don't have any family or guardians around? Right? This is what we're trying to do is to prevent child protective services from coming in the home, taking the kids out of the home and putting them in foster care until family or guardians can get to the children. I see this so often for families that relocate to an area and have no family around, right? This is why it's important to be able to then say, okay, who is in our life that our kids are comfortable with, that within 30 minutes they can be to our kids to make sure that they are safe and protected and in their home and feel comfortable until family or guardians can be able to get to them. Okay. And so it's identifying those people and making sure that they are listed as short term guardians so that there's no question, right? That it is your wishes that they stay with these short term guardians until family is able to get to them. Okay. The last thing we're going to talk about in these five considerations is minor children can't actually inherit money or property. And so a lot of times parents have life insurance policies, which I think is very important. It is something that is very responsible as a parent to make sure that if something happened to you, that there's money that would help take care of your kids, right? That's why a lot of parents will have life insurance policies. But the logistics of how life insurance policies actually work is if you list your minor children as a beneficiary, and I see this often if there's maybe a single parent or a divorce has gone through and they don't want their ex-spouse to get the money. And so they will list their minor children because, of course, they want to make sure that their kids are protected. But if something were to actually happen to the parent and that money was to go to the kids, the insurance company wouldn't allow them to actually receive it. There would have to be a guardianship hearing where that it would be another court process that would cost a lot of money to have to go through. And then once that court proceeding was done, that money would go into a court blocked account where the kids wouldn't even get access to it until they were 18 years old. And oftentimes, parents don't understand that the money wouldn't actually be there to be able to take care of the kids, right? That is the goal with a lot of these life insurance policies is to make sure they have money to be able to help support their needs. But that it doesn't work that way if it just has the kids listed as a beneficiary. And there are ways around this, and I'm going to get to that in just a moment. So don't fear, we have a solution for it. Okay, so when we look at estate planning, there are kind of like, I call them like the big five from an estate planning perspective. And when we do estate planning, we do a comprehensive estate plan. And so it has these big five and a bunch of other documents that help with different things. But for our purposes for this, I just want to kind of make sure you understand that when it comes to estate planning, it's not just one document, it's all of these documents together. Power of attorney, advanced healthcare directive, also known as a living will, how most people know it. We have HIPAA authorizations, a will, a trust, and guardian nominations for minor children, both long-term and short-term. So it's not one of these documents that makes up an estate plan, right? Because one document does generally one specific thing or a group of things. All of these documents work together to make sure that you have legal plans in place to make sure that your wishes are legally documented and that your assets and your family are protected. Okay. Okay, so I want to focus on two of these things because these are the big questions that I hear from parents with minor kids is about wills and trust. So what is a will? Well, a will is a legal document in which you give certain instructions to be carried out at your passing. And so in your will, you can say how you want your assets distributed, right? Where you want your money to go, where you want your property to go, who you want it to go to. It also allows you to nominate guardians for your minor children. When somebody passes away, that is when a will is actually filed with the probate court, thereby becoming a public record. If somebody passes away in the state of California and they do not have any, if they do not have a will in place, then California has an estate plan for you. It is called intestate succession. And it's basically here's how your stuff is passed down according to your family tree. Oftentimes, people do pass away without having a will, and it passes this way. The problem is that depending on your family situation, you may not want things to pass how that intestate succession would actually work. You know, maybe there's a remarriage. Maybe you have somebody that you think of as a kid, but they're not actually legally your kid, right? They wouldn't inherit from you. Depending on how your assets are held, there may be issues with your assets not just all going to your spouse. It may have to be split up between your spouse and your children, right? So these are the reasons why having a will and other estate planning and documents is important and not just leaving it up to chance. Because when you leave it up to chance, you have no say in how things are actually done. So the biggest myth that I hear when it comes to probate court is that having a will avoids probate court. And this is not true. Having a will alone is almost just guaranteeing probate court because it's telling the court how to actually distribute the assets. Okay. Okay, so let's move over to a trust, also known as a revocable living trust or a living trust. These are all kind of interchangeable names that mean the same document. So a trust is basically just an agreement, and it is an agreement between the grantor, which is the creator of the trust, and the trustee. The trustee is the person who agrees to hold legal title to all of the assets in your trust. And the trustee will then follow all of the instructions in your trust for the benefit of your beneficiaries. So, three terms I just threw at you: grantor, trustee, and beneficiary. While you are alive and you have a revocable living trust, you are all three of these roles, right? You are creating the trust. You are in charge of all of the assets in your trust. You can make changes to your trust at any time. You are also the beneficiary. All of the assets are there for you to use however you want. The myth that I hear when it comes to trust are that trusts are just for wealthy people, right? I'm not Bill Gates level. But in all actuality, trusts are for the average family, right? Making sure that if you own a home, right, how those assets are going to be distributed if something were to happen to you, whether you were to get sick, which is when a trust can come into play to help take care of you, or if you were to pass away. It legally puts all of that in writing. Okay. Okay, benefits of a trust. So, especially when it comes to minor kids, having a trust has so many benefits that people really don't understand until they start working with an estate planning attorney or following us on Instagram to get information. But this is some of the things that I think are so important when it comes to planning with minor kids because you have the ability to put all of these plans in place. So when you have a trust, you could say in your trust, well, if something were to happen to me, I would want my trust to have sub trusts that are created as a result of my passing to be able to put money for my children to be distributed at ages that I set, maybe 25, 30, 35, really extending how they would receive money rather than getting it at 18 years old through the court system. Having a trust allows you to protect your children's inheritance from predators, and divorce, or potentially if your spouse, if the surviving spouse were to get remarried, right, in some type of blended family situation at that point, you can have your trust set up so that it would protect those assets that were yours prior to your passing, right? And for some people, this is really big considerations that they want to make sure these protections are in place. Having a trust allows you to choose the trustee that you want to manage the finances and assets of your trust. It could be a guardian, right? So if you have the guardians that you've chosen for your minor kids, it could be them that get to manage the money, but it doesn't have to be, right? That's the great thing about this is whoever you're choosing these roles are your choice because you're making these wishes while you are in good health. And it's only if something were to happen that that's when these would come into play. Another really great benefit is being able to list your trust as a beneficiary on your accounts so the funds don't have to go to your kids. So remember when I talked about life insurance policies and how, if you list your minor children on a life insurance policy, they can't actually inherit that money, it would have to go through the court. Well, here, if you have a trust, you could say, well, for my life insurance policy, I'm going to have the money go to my trust. So I'm going to have the trust as the beneficiary. Now, instead of it going directly to my kids through court, it's going to go through my trust where they're going to get the money at 25, 30, 35, whatever ages I set, because it's going through my trust and not to them directly. Right. And there's a lot of things that we can do to be able to put those wishes in writing to make sure that your assets are protected, that your kids are protected, and that they're cared for in a manner that you choose. Okay, so just a quick kind of diagram of what the difference is between a will and a trust, just kind of an overview when it comes to minor kids. So having a will allows you to nominate guardians for your minor children. We can put that in the will. Remember, the will is a public record. So this is something that is filed only when somebody passes away. That's when a will is filed with the court, thereby becoming a public record. Now, from a trust perspective, a trust avoids probate court because those assets that you have are going to be titled in the name of the trust, thereby nothing needing to actually go through probate court, which avoids it saving time, money, and that public side. Okay. If you own a home, having a trust would allow you to then put your home in the name of your trust. And then if something were to happen to you, again, it would avoid probate court because now it would be distributed according to the terms of your trust. Same thing with retirement accounts and life insurance policies. You can list your trust as the beneficiary. Again, this is when you have minor kids. You can list the trust as the beneficiary to make sure that rather than that money go directly to your kids, it's going into the trust to be distributed at ages you set. Now, all of this takes into account what your family situation is, whether you're married, whether you have adult kids, minor kids. This is really just kind of a blanket if you have minor children, right? Some ideas. But that's why it's important to work with a professional, with an estate planning attorney, because then we can look at, okay, what are your goals? What is your family situation? What are your assets? If something were to happen to you, what do you want to happen? And then how do we set up a plan that makes sure we're going to get the best tax savings for you, that it's going to take into account what your wishes are and how that money would be distributed and protected. And then the last one there, predator protection for kids. Having your assets go into trust allows it to be private, right? So it's not going through that court system, which is a public record, which means you don't have potential predators coming after your kid's inheritance because the trust information is private and it's not going to be with the court system, thereby allowing your kids and the assets that they could be receiving to stay protected. So when it comes to a will and a trust, you don't have to decide which one is best, right? Because honestly, a comprehensive estate plan will include both a will and a trust. A will acts as what we call a pour over will, and its function is only to nominate guardians for your minor children and to say if something were to happen to me and I do not have any assets and some assets got left out of my trust, maybe my house, I refinanced it, it get put back in, it just gets poured over into my trust. And then everything stays private through the trust system. Okay. And so that's why we talk about having a comprehensive plan with those big five. It's going to include both a will and a trust in these circumstances. And that's really where it comes down to you making a decision on what's best for your family. What is your goal? What are you trying to accomplish when you look at doing an estate plan? Okay, so who needs planning documents? Anyone over the age of 18, but especially if you have minor children and or own a home. You need to have some legal documents in place. And that's where, again, working with an attorney to understand what are the solutions for you to solve your problems to make sure that your family's protected, your assets are protected, if something were to happen to you. Because that's all we're planning for is the if. Okay, so if you need help getting started with your estate plan, maybe you don't know where to get started, you want some more information, please schedule a free phone consultation with a member of our team to be able to get information. What is estate planning? What could happen in your specific situation without a plan in place? In that consultation, they'll go over the different packages that we offer to see if we can find one that's right for your family. In addition to that, we also have a kid safeguard system. So this is a digital system. So maybe you know you need some type of estate planning documents in place, but now after watching this and hearing everything about guardian nomination, you really just want to get started with that first. So our digital kid safeguard system is about those protections for kids from the guardianship perspective. So this kid safeguard system includes nomination of long-term guardians, as well as letters to those long-term guardians, nomination of the short-term guardians, and letters to those guardians. We also have a confidential guardian exclusion. Maybe there's somebody that you would never want to be guardian for your kids. Well, you can put this in a letter that would come up as confidential and only to the court if something were to happen to you and they petition the court for custody of your kids. It also includes family emergency information printable and a bonus wishes to guardian printable. These are things over the years that families have just expressed an interest in needing or wanting to be able to communicate things that are important to them, family traditions, things they want to make sure that the kids know so that they can put that in writing to their guardians to be able to communicate it to their kids. This system is only available in California. And after you watch this webinar, you should get an email and it's going to have a link to both scheduling that free phone consultation to get more information on estate planning, so wills and trust, the power of attorney, advanced healthcare directive, all of that. That is a free phone consultation. So check your email for that link, as well as the link to get started on your digital kid safeguard system. So both of those links will be emailed to you so you can get started, get legal plans in place, get information, and really do what you feel is going to be the best fit for your family, because that's really what this is about. My goal whenever I do webinars is really about education. I hope that you were able to get information that you didn't know before that's going to help you make better informed decisions. And then please share that with your friends and family, because the more that we're able to give information out and let people know what actually happens, and maybe that estate planning isn't so scary, is going to allow more people to put their legal plans in place and get their family protected, giving them peace of mind. I want to thank you so much for joining me today. Again, I hope that you found this webinar very useful, and make sure to be on the lookout in your email for those links for those webinars. And if you have any questions at all, please feel free to send us an email and go to our website or give us a call. Thank you and have a wonderful day.